right, good afternoon and welcome to our training for the Anoka County Housing Court Clinic. Thank you so much for attending today. We're really appreciative to have you here. We're also very excited to be a part of the Housing Court Clinic in Anoka County. Anoka County has been providing services at the Housing Court on Mondays for quite some time. Both Judicare of Anoka County and Central Minnesota Legal Services have been out here most Mondays a month. Starting this fall, a group of interested individuals, including the 10th Judicial District, many other people in the courthouse and out here in Anoka County government, the Family Housing Fund, Volunteer Lawyers Network, Emergency Assistance of Anoka County, all got together and talked about expanding the services that were being provided at the Housing Court. And that's how Volunteer Lawyers Network got involved. Right now, there are initial appearance calendars in Anoka County on both Monday and Wednesdays afternoons, Monday and Wednesday mornings. And our goal is to have 2 attorneys at every initial appearance calendar. So that's where Volunteer Lawyers Network comes in. We are working on training up attorneys, so we'll have an attorney every Monday and Wednesday morning at the initial appearance calendars. So with that, this is going to be our training. We're going to make this available to those folks online who weren't able to be here today. The training hopefully is going to give the basics that you're going to need when you're at the Housing Court Clinic. Also part of our training not only is going to be this online training in our materials, but then we'll also do training through shadowing. So people who are interested can start by reviewing the materials, and once they feel comfortable with those, contact Volunteer Lawyers Network, and we'll get you set up with a staff attorney who will shadow you on your housing court shifts until you feel confident to take them by yourself. We are asking people to make a 1 day a month commitment, which would be 1 day, Monday or Wednesday from 8:30 to 10:30. As for our training today, I have Larry McDonough here, pro bono counsel from Dorsey Whitney, who has been involved in all things housing law in Minnesota for quite some time. And he is going to be here to do the first part of our training, and he's going to talk about eviction defenses and a few other issues. Then we'll take a break after an hour of that training, and I'll come back and I'm going to talk a little bit more about the nuts and the bolts of the Anoka County Housing Court Clinic, and then I'm also going to talk about eviction expungements. So with that, I'd like to welcome Larry.
All right, thanks, Mariah. I'm going to spend some time over here in front of the screen, some time over at the computer, so we can actually look at some stuff on this screen as well. So my background is I worked in civil legal services programs for about 35 years, primarily in the housing and consumer area. I've been at Dorsey & Whitney about 6.5 years now. I manage our pro bono litigation program, but I also keep my hands in all things housing. So, matter of fact, I'm at the legislature right now working on some bills that might make for more tenant protections looking forward. So you should have a binder, and it has really everything that you need to get oriented to it. It is a little bit thick, but don't worry about that. You don't have to become encyclopedic about this area to do it. I am encyclopedic about this area, but don't hold that against me. You can do this work, and you don't have to know everything for every case. For instance, if you're talking to someone who's got habitability issues in an eviction case, you don't need to be looking at materiality of breach. You don't have to be looking at waiver of notice, things like that. So part of what we're going to do today is to try to help you kind of center in on what the issues might be on a particular case so that you can kind of focus your inquiry asking questions for the client and help that person figure out if they have some legal defenses or not. So I'm going to move away from here for a moment and go through this outline a little bit and show you where some of this stuff is on the internet. Mariah, will people have an opportunity to get a digital copy of this outline, do you know, or not?
Yes, we'll make it available with the training.
Yeah, and so when you have this outline, you'll be able to click on the different links, and those will take you to places on the internet. I maintain a website where I keep, it's a teaching website, but it has a lot of housing things on it, and pretty much everything we're covering today you can find on that website as well. So first I'm just going to show you where things are, and then we'll get into the nitty-gritty of how eviction cases work. So this outline I put together, it's also got my contact information on it. Feel free to contact me as well. I'm also willing to partner with people when they're going to clinic and getting oriented. If you've been to clinic and you want to debrief about how it went, I'm happy to do that. And if you're at clinic and you want to call, and if I'm available, I take calls from volunteer attorneys at different clinics as well. So feel free to use me as a resource as well. Okay, so I'm going to show you around the internet a little bit. Everything that I have, the launching point for that is my poverty law website, and you have a URL for it there. I'm just going to shift over to that now and just show you what it looks like. So this website is a teaching website for other topics as well, but this is the main page for housing. If you ever got to this website and you were just at the home page, the way to get to what we just saw is you just go down to reading, and you can pick either Poverty Law 1 or 2, because housing is covered in both of those. And just click on the housing link, and it'll take you back here. Okay. Or this site's been up for a long time. If you just Googled my name and poverty law, it would probably come up pretty high in the feed. Okay. What I have on this website, I have eviction answer forms. I have slideshows about different issues like expungement, doing motions to vacate judgments, informal pauperous fee waivers, pretty much anything that you might think would be connected with doing tenant representation, you can find somewhere on this website. What a lot of people use this website is to do research. And I have a very large eviction defense manual on here. If you're going to look at it on your computer, I'd pull up the HTML version, and you can go down and get to the table of contents. Let's say we're going to, in a few minutes, go through a summary of evictions. That would be here. I've got it broken down into different chapters related to different types of defenses, like non-payment of rent, holding over, things like that. It's long, so don't print it off unless you really want the temperatures to go up a little bit higher in the world. Use this as really like an internet encyclopedia, and because it is over 600 pages at this point. All right. So some other things to be aware of. So we've gone over that. I have a section called Housing Law Links, and that's just a little further down here. And I use this is so people can find other sites that are useful. Where I use this most, and I've got favorites here, and so these are the things that I use the most. If I want to look up someone's eviction court record remotely, I can do that there. If I want to look up whether a business is registered with the Secretary of State, we'll get to the relevance of that in a few minutes. I can do that here. I've got also some sites for looking up ordinances and different landlord-tenant laws and things like that. So, you can just browse through this at some point. I've got, rules and ordinances, courts, case investigation, a lot of different things on there. Pro-Justice MN is a kind of like a sister website to mine. It was organized by Legal Services and the Bar Association, and it's more of a full-service website, while I'm showing you things that are mostly related to housing law. If you haven't gone to that website, you should register and go into it. It's got really great libraries on all different types of practice areas that impact poor people, family law, consumer law, and the like. Housing fact sheet says if you've never gone to the Law Help Minnesota website, I've got that up here, and it's not so much a research website, but when I worked at Legal Aid, probably about 35 years ago, we were developing short summaries of the law for clients, written at a very understandable English level, not very dense documents, and then later on we created this website and digitized them. And so there's this great self-help library. So if you wanted to read up on some topics that you think you may be a little less familiar, like security deposits or something, you could read a 3-page fact sheet on it and basically get the gist of what the rules are for that. People can also use this to do intakes with legal aid and to find legal aid offices near them. I mostly use it because this library is really handy. Okay. The statutes, Minnesota Chapter 504B is the main landlord-tenant chapter. There are a few statutes sprinkled elsewhere, but most of it is right there. And you have that printed out in your binder. Probably not going to go into that today, but if you ever want to, take a look at the exact statutory language, if you think something might hinge on that, I think this is a cleaner website than just going and looking through Lexis or Westlaw. You can just get all the statutes without the annotations. If you ever run into someone who has a mobile home park lot rental, and all those words actually are relevant, it's someone who's renting a lot space on which a mobile home that they may own sits. They rent the lot space. There's another chapter of Minnesota law that applies to that. If you're ever seeing anyone who's has that landlord-tenant relationship with a mobile home or manufactured home park, you'll want to be looking at this chapter, but you don't really have to look at that chapter because I have an answer form that connects to that type of case, and I'll show you where that is in a moment. It's not in your packet because we don't see a lot of those, but we certainly see them occasionally. I've got a website for Minnesota ordinances. Well, just before that, there are housing court rules, but they only apply to Hennepin and Ramsey County. Other courts can apply them if they want, but for the most part, you probably won't be seeing application of those rules here. Lots of cities have ordinances. A lot of cities have ordinances that relate to landlords and rental licensing. And even though we're in Anoka County and Anoka is just one city, it is a big city in Anoka County. And it does have a rental, it has both a property maintenance ordinance. So if you were to click on the link that I just showed you, it would pull this up. It's got maintenance standards, and so it has housing inspectors. A tenant can request an inspector to go out and look at her property and to cite the landlord if it's not in compliance. You can see there are a lot of things that are covered here. It also has a rental licensing program, and a lot of larger cities have these programs, and a very common element, which is included in the Anoka one as well, is that a license is required to rent out property, and that it is a misdemeanor offense if the landlord rents out property without licensing. And the fact that it's a misdemeanor offense gives rise to case law that says that the tenant may not owe rent for a period in which a property that was required to be licensed was not licensed. Now, some cities have their licensing information online. I haven't seen that in Anoka County, so I think, or in the city of Anoka. So I think if you wanted to find out if a property was licensed, you'd have to call up the city of Anoka and talk to the licensing department and find out if it were. Okay. So I'm going to talk a little bit about the eviction process and then go into the different defenses that apply in evictions. So in your packet, in your binder, it's, the summary is starting around page 90. It doesn't actually have a number, sequence number in it because I put together these things separately from the rest of the binder, but that's where they sit in the binder. So if you kind of start paging up to number 90, and then you'll see something starting with number 1, and that is the summary. So I'm going to pull that up on the screen so we can kind of walk along with that. So I'm going to go back to my eviction defense manual. And when I'm looking at it in a browser, I use an HTML version of it. You can certainly look at other versions if you want. But if you're on your browser, I'd say this is the best one because the links take you back and forth as if you're flipping pages. So I'm going to go down to the summary, and we're just going to walk through how eviction cases work. So an eviction action is commenced by a landlord or landlord's attorney going to the court and paying a filing fee, and the court prepares a summons with a court date on it. This is different than other types of litigation in Minnesota where the attorney will prepare a summons and complaint, serve it on the other side, and nothing is docketed into the court system until somebody needs the court to do something. Here, by statute, the court prepares the summons with a specific court date. So the landlord pays a filing fee, and then the court prepares a summons with a specific court date on it. The court date is within 7 to 14 days of filing. Usually landlords push it back closer to 14 because they have to have some time for service. Okay. Service can be done a number of different ways, and we'll talk about that more specifically in a few moments, but it's something that I look closely at service when I'm looking at eviction cases, because the case law tells us that strict compliance is the standard, not simply substantial compliance. So it has to be done exactly right. And because in this area of law, there are more pro se plaintiffs than other areas of law, sometimes they get service wrong. And so I always really kind of hyper-analyze service, and we'll talk about that in a few minutes. Tenants can file written answers, but they don't have to. The statute that talks about answering a complaint uses answer as a verb, not as a noun. And so tenants can do that orally, counsel can do that orally, or it can be done in writing. If you are going to file a document, there's going to be a filing fee, and that applies to both tenants and landlords. The base filing fee is around $300. Most low-income tenants that are going to be coming to this clinic aren't going to be able to afford that, and they're probably going to be able to qualify for a fee waiver. Now, if you don't file anything, you don't have a filing fee. So if a tenant answers the complaint orally, there's no filing fee. If the tenant is going to submit an answer, then there's going to be a filing fee. And so to avoid that filing fee, the tenant would have to file an informa pauperis or IFP waiver request, and the court would then have to say waiver is appropriate. For most of the people that will see our clinic, really probably all of them, they're going to be eligible for this. But again, if they're not going to file anything, you don't have to go through it. Now, attorneys have to e-file, and that gets a little bit problematic in this environment. So let's say I'm seeing someone at clinic and they have a court hearing today. If I were to e-file something for them, I'm not going to get a confirmation of acceptance of that filing for probably 2 or 3 hours. That's about the fastest I've seen the e-filing system react. So if I'm e-filing something, it's not going to be in anybody's queue in time. So what I do is if I'm seeing someone who needs to file something for a hearing today, I draft it, I have them sign it, I have them file it at the desk, because they're not required to e-file. And so then you're getting it in faster. But you still need to give some thought, is it worth the time to do that? Let's say I have an eviction case and the only defense is habitability. I could advise the tenant and maybe even create a little script for the tenant on how to say, my apartment is in bad shape, I've got a housing inspection report here, I'd like to have a trial on how much rent I actually owe, and hopefully order the landlord to get repairs done. You don't need to have an answer for that person to do that. Now, if I was helping someone with 6 different defenses and some of them were getting into nerd zone, then that might be a little complicated for someone to articulate who's not a lawyer. Then having the answer might make sense. Now, if I'm seeing someone at a clinic, on Monday and their hearing is on Wednesday because they actually came in early, and if I'm going to represent them in the hearing, then I might be fine with doing the e-filing on that, because I'm going to be attorney of record, and the fact that it takes a couple hours to get through the queue is not going to be problematic. I think more often we're going to be seeing people who have hearings the day of our clinic, and that we may not be representing them in the court hearing, and so if they need something to be filed, probably having them be the signatory for that is the way to go. But again, if they're going to file something, you're also going to have to take the time to do an informa pauperis waiver, and that takes, it doesn't take hours, but it takes a little bit of time to do that. So part of what we try to do in clinic is kind of think about time management. How much time do I want to spend with this person relative to the people that are waiting? And that includes perhaps the judge and the landlord on the other side and the other people that are waiting to see that. So it's always a little bit of a judgment call as to how much time I want to devote to a person, and that helps me figure out, am I going to draft a lot of things, or this is going to be more of an oral presentation. Okay. The first hearings I've got for several different courts down here. I'm just going to go down to Anoka. Again, Anoka has its hearings on Monday and Wednesday mornings, and that's when our clinic is. Most cases will be disposed of there. People will either settle their cases will get dismissed, or if they get scheduled for a trial, probably going to be within the next week or so. So if you're thinking that you want to help someone with a trial, that's kind of the time parameters you'd be looking at. And if you decided you wanted to go in with a person and then make that trial request for them and sign on as an attorney, have a calendar with you, whether it's on your phone or your computer or a hard copy, because you can be a little bit in the driver's seat of the scheduling on that. I've never had a judge or a referee when they've said, well, when are you available? And I say, well, I'm available here. They said, well, tough, I'm going to schedule you here. I think you've got a little bit of, you can be in the driver's seat a little that way, because the court would rather see a lawyer with a tenant than without. Okay. You can remove judicial officers. Now in Anoka County, we're going to have judges hearing cases. In Hennepin and Ramsey, we have referees, a mix of mostly referees with some judges in Ramsey County. Duluth, we're having both kind of referee and judges. And Anoka, it's just judges. But there's no specific judge assigned to this, so it's going to be a rotation. If you may not know who the judge is going to be. If you were going to do a removal of a judge, you do have to do it before you appear in that hearing with that judge in this case. Once you've done that, you lose the right to remove that. I don't have enough experience with the bench up here to, in my view, kind of size up who might be, a little more pro-landlord, pro-tenant. No one's going to say they're that way, but people have their own kind of dispositions. And when you practice in a court, you start to get a sense for that. So I'm not recommending that people remove judges at all. If you've got some experience over a period of time and you think a judge might not be kind of open to your thinking on a case, then that's something to consider. But again, you have to do that before you set foot in a hearing with that judge. Trials are really like any other kind of trial. They go a little faster because usually the issues are maybe less diverse. The cast of characters in terms of witnesses tend to be smaller. I've done probably about, 250 or 300 trials in my time. Granted, I'm an old guy, so that's why I've done that many. But we're not talking trials that go on for weeks and months. We're talking about trials that often are a half day or less. Anywhere from a couple hours. I've had trials that have gone a couple of days, but even 2 days I would say is the outlier, and even a full day I would say is probably the outlier. I want you to know a little bit about the end process of eviction cases because that's relevant to when you're discussing settlement cases. So let's say we have a case today, and let's say I'm the tenant and I lost, or maybe I don't have any defenses. What's my status? Okay. I can ask the court to give me 7 days to move for hardship. Most judges and referees understand that it's hard for folks to move, and especially folks with limited incomes. So getting that 7-day stay is relatively common. Okay? So that means I don't have to move for 7 days. So that takes us off to next Wednesday. If I hadn't moved at that point, the landlord would have to engage law enforcement to make me move. The way they do that is they get a writ of recovery. So what I just essentially asked, I asked the court to stay the writ of recovery for a week. So that means the landlord can't get it for a week. And the landlord can't get law enforcement without the writ. So the landlord goes to get the writ, the landlord pays a fee for that, and then landlord takes it over to the sheriff's office and then also pays a fee for the sheriff to serve that writ. That'll probably happen the next day, so now we're talking a week from tomorrow. The writ says I have to be out in 24 hours. If I'm not out in 24 hours, then the landlord can schedule the sheriff to do a move out of me. So now that 24 hours takes us over to a week from Friday. And then the landlord calls up the sheriff and says, Sheriff, he didn't move. I need you to go make him move. The scheduling of when the sheriff comes out is going to depend a little bit on how busy the sheriff is. Doesn't take a lot of time to deliver a writ. It takes more time to supervise a move out. So the idea that the sheriff would maybe come out the next day on Saturday seems a little bit improbable to me. Seems more likely that might be the following Monday or Tuesday, but you don't know for sure. Now the landlord is supposed to send a letter to the tenant saying when the sheriff is coming out to do the move out. In my experience, a landlord community is kind of sketchy on that. Some do it, some don't. So you can't rely on the fact that the tenant should actually get notice of when the sheriff's coming out the second time. I think that potentially would be grounds for reopening that aspect of the case, but at that point, usually the tenant's scrambling and is not kind of devoting that kind of time into still trying to fight the case. So that part of this process, I think, is still a little bit wild, wild west, where some landlords are actually giving that notice and some aren't. But now you can see with the time parameters. If I'm talking to a landlord today and the landlord says, well, pay me $1,000 and move out on Friday. Well, that's a bad offer, because I could pay nothing and probably still be on the property for at least a week to a week and a half. Now, if the landlord's saying, well, pay me $1,000 in 3 installments over the next month, and I think that's affordable and I can actually then get back on track with my rent payments, that's not necessarily a bad offer, because the court's not going to give me a month to do a payment plan. It could, but in my experience, doesn't. So I think most judges and referees tend to say, tenant, I'll give you a week to settle, to pay what you owe, but I'm not going to extend this out further. Now, the court has the authority to go further, but I haven't seen courts using that kind of authority. So it's good to understand this process at the end, especially in evaluating offers in terms of payment plans and moving. You can appeal to the Court of Appeals. You can appeal to a judge if you have a referee, but we don't have referees in Anoka. So if a tenant or landlord were to lose a case in Anoka County, their next step would be appealing to the Minnesota Court of Appeals 15 days from entry of judgment. Usually entry of judgment happens when a writ is issued. So that's usually the time parameter you're looking at. The court you can ask for a stay of the eviction pending the appeal. But doing appeals, if you haven't done appellate litigation, it's kind of nitty, and there's a lot of paperwork involved, and so 15 days is not a real long time period to kind of get all that together. If you're ever looking at helping someone with an appeal, I'd be happy to talk to you about that, because I've done a lot of those over the years. Expungement is an issue, and Mariah's going to talk about that, but it's something to be discussed in terms of settlement. Expungement would be essentially sealing or making the public court record private so that the outside world isn't able to go back and look at this case. Now, Mariah will go into the logistics of the housing clinic and how we're going to handle shifts. I just wanted you to know that this is not kind of a brand new thing out of the box statewide. It is, it's kind of a new expansion for Anoka County, but we've had a housing advice clinic here for a while. We've had housing clinics in Hennepin and Ramsey County, other places in the state. But I wanted you to be aware that there's a special rule related to, in the Minnesota Rules of Professional Conduct, for serving in these kinds of clinics. And I've got the relevant rule here, but basically the gist of it is that you don't have to do conflict checks when you're serving at a clinic. Okay? Now, if you know you have a conflict, you just know you have a conflict, then you can't serve on that. So, for instance, our law firm represents U.S. Bank. If I'm at clinic and U.S. Bank has a post-foreclosure eviction case against someone, I know I can't serve on that one because I know I have a conflict. If it were some other property management company and I don't know that we've ever done any work for them, I don't have to check and see. Okay? So one, you don't have to do that. And two, you can have a limited kind of service role with this person. You can give this person advice, but you don't have to go any further than that. And we have an intake form that discusses that relationship with the client, and so the client will know that this relationship may have a very short time period to it, Of course, you could extend it out further if you want, but that's not an obligation of you when you do these clinics. Okay. Any questions so far on just how this process works? Okay. So what I'd like to go to now, yes, question.
You mentioned that it would take up to a month. So let's say that you're negotiating with the landlord, right?
Mm-hmm.
And then the landlord says, okay, I give you a month and I will pay you for you to leave. But what if the person doesn't leave at the end of the month?
Okay, so the question has to do with when you might be negotiating for payment plans. So in my view, a payment plan only makes sense if the landlord's saying you get to stay. Okay, so let's say I'm $1,000 behind on the rent and there's some habitability issues. And our settlement agreement could be that, and let's say that I can afford the rent going further, but I had trouble with the rent because I had less hours this month for work. Okay, so I think I can afford it down the road. If I were to just ask the court to give me a month to pay this up, I don't think the court would give me that amount of time. But if the landlord's willing, so the settlement agreement could be, okay, landlord, you fix these 5 things by next week, and the $1,000 that I owe, I'll pay in 3 installments over the next month, along with my rent as it comes due, and then I don't get evicted. Okay, so that would be the scenario in which you'd be discussing those kinds of things. Does that make sense?
Yeah.
Okay.
But then if you don't move out, let's say that you break the agreement with the landlord, then the landlord will start again the process?
Okay, good question. So the next question is, if I break that agreement, does the landlord have to start over again? And the answer is no. So the settlement agreement is essentially a contract within the parameters of this case. And so the settlement agreement probably would say that if I don't meet my obligations, that the landlord can continue with the process, which at that point doesn't mean having a trial. That means engaging, getting that writ of recovery, and then engaging law enforcement if needed. So usually the settlement is a disposition of the case without a trial, and then if it falls apart, it generally doesn't lead to a trial unless there's a factual dispute over whether it actually were breached or not. Okay? All right. So I've talked about kind of the process. Now I want to show you some things that kind of help analyze cases. Now, the website that houses Law Help and Law Help and Pro Justice Minnesota are kind of closely intertwined, kind of sister groups. And Pro Justice Minnesota has a nice eviction interview form that you can use with folks. And, you know, it wouldn't be bad just to take a look at that sometime. It kind of walks you through kind of ways to ask questions to get at different areas that are relevant to eviction defense. What I'm going to do is go to my eviction answer form and use that as a way to walk through that. The eviction answer form is right after the summary that we just did in terms of your binder. I'm going to pull it up here on my browser. Now, if I were going to find the eviction answer form on this web page, very high up on the web page, there's a link which takes you down to answer forms. It has a few different cases, but then it goes into different types of answer forms. The one that you've got today is answer form A1, and that's the most applicable to cases. The other ones are more specialized. The manufactured home park one I mentioned that's not in your packet is A2, and then the rest of them deal with different types of subsidized and public housing programs. If you ever see someone who's in a subsidized or public housing program, since we're not going to cover that today, I would say, you know, reach out to a legal aid person. And part of the partnership with our clinics is that we're working with both Judicare and also Central Minnesota Legal Services. Those are both staffed legal services programs, and they have people that do this stuff all the time, like I did when I used to work there. And so if you have a subsidized housing program case, or maybe even a manufactured home park case, it might be good to talk to one of them. Now, Mariah, when we're doing clinic shifts, is the idea that there would be someone from one of those programs and one of our volunteers on the same day? So you'll have that access to someone right there on site as well. But also feel free to give me a call if you've got one of those, and if I'm available, I could help walk you through it. So I pulled up on a separate tab here the answer form that you have in your packet. Now, I don't have time to go through all of it, but I want to walk you through some of the main points and show you how I use this. So I started developing these about, I don't know, 30 years ago, because I was running into, these cases obviously move pretty fast. And in a pre-internet era, I found that the less time I would spend drafting things, the more time I could spend getting to know my client, because the time frame's so compressed. Now, in the era of e-filing and the delays that are involved with that, I use this form less as a pleading, and I use it more often as a triage document. But you can certainly use this as a pleading by checking off boxes and signing it and filing it or e-filing it. So I always encourage people to talk to the tenant about the specific allegations in the complaint. You might think that since the complaint's on only a one-page document, it doesn't have that much information in it, the landlord probably hasn't screwed it up. But I see enough of that so that I want to ask every time, is this right about the rent? Is this right about the move-in date? Is this right about late fees? Figure out if it's right, because there are times when it's not. It's always good to have in your mind, are you dealing under B here, a tenancy of a specific length or a month-to-month tenancy? In rare cases, you're going to see foreclosed mortgages or contract or canceled contract for deeds as a basis for the eviction case. I'm not going to have time to go into that today. That's another situation where if you're seeing that, the answer form does highlight the different defenses that apply to them. And there are some in each of these kind of compartments, but you're not going to see many of those. You're mostly just going to see landlord-tenant relationships that don't involve that. There are some differences between a month-to-month tenancy and a term tenancy of a specific length, and so that's why it's a good idea to kind of get that figured out before you start looking at other things. Now, I'm kind of a chronologically based person, and so if it's a non-payment of rent case, I don't want to talk about non-payment of rent until I figure out if service is right. And again, the reason why we should always care about service when we're doing litigation. If you're on the plaintiff side, you want to get it right, and if you're on the defendant side, you want to see if it's done wrong. But there's a higher percentage of error here because you have a higher percentage of pro se plaintiffs. So the reason I have the string cite in here is just to when I use this as a pleading, to just reinforce with judges that this actually matters, that personal jurisdiction is an important concept, and if you don't have it, the court has no power to do anything. But the main types of service, the things I look at are, was service done at least 7 days before the court hearing? And 7 days, so essentially means a week. So if I have a court hearing next Wednesday, service has to be completed by today, not at the exact time of day, by the end of the day. So if I have an 8:30 hearing next Wednesday, if service is complete by 11:59 p.m. tonight, it's good. Okay? The court papers can't be delivered on a legal holiday. Service on a Sunday is okay. Basically, court holidays are the wrong days to be serving court papers. The person who serves the court papers is supposed to be wholly disinterested in the case. So the plaintiff is not supposed to serve court papers, but also people that are kind of in the hierarchy of the plaintiff aren't supposed to be doing it either. Okay? Now, if you ever wanted to read up on more of these things and just say, well, Minnesota Rule 4.02 doesn't say anything about hierarchies. It just says the plaintiff's not supposed to do service. So how do you get this hierarchy thing? Well, you get it out of the case law, and the Lewis case is probably the best appellate decision on that front. But if you were to go to my manual and look at this section on service, the identity of the server, you'd see that there are a number of district court decisions that say that the manager, the caretaker, is the wrong person for delivering the court papers. Now, there's personal service. There are a couple different types of substitute service. Number 5 is substitute service on a person other than the defendant. Okay? So what does that mean? Let's say there are co-tenants, and they both are defendants in the eviction case, but the server comes by and only finds one of them there. Can that person serve that one person for both of them? Generally, yes, but there's some parameters on that. Okay? First, you have to have not been able to find the second person.
The person who receives the court papers for the second person has to reside with that person. So if we have roommates, that's okay, but if it's a babysitter, it's not. Okay? The person has to be of suitable age and discretion. So again, where I see problems here more is with the babysitter. If you have a 10-year-old babysitter, looking after a 2-year-old kid, maybe not a suitable age and discretion, and if that person doesn't live in the unit, that person doesn't reside there. Finally, the court papers have to be delivered at the unit. So if you find one of the tenants at the grocery store, you can personally serve that person at the grocery store, but you can't use that person for substitute service on another person because that service has to happen at the residence. So there are more parameters on substitute service than personal service, and that's because it's an indirect way of getting the court papers to this other person. I mean, if I'm the server and I just deliver them to you, you've got them. But if I'm giving them to somebody else for you, there's another chain in there, and that's why there are more parameters on it. Number 6 here, there are also a number of parameters related to mail and post service. So this is only available if the server can't find the tenant, can't find someone for substitute service, like a roommate or something. And so and you can look at the different boxes here, but essentially what's involved is the server has to go out to the property on 2 different times, 2 different days, at least one of those in the evening, and be unsuccessful. And only after that can that person mail a copy of the summons and complaint and then go back to the property and post it. So there's a sequence involved. And so what's laid out here are a number of different defenses related to either missing elements of that sequence or doing it out of sequence. When I'm looking at service, I talk to my client, find out, how did you get these court papers? But the nice thing about clinics on site is that you can then look on a court computer and look at the affidavits of service and see what actually happened. So where I frankly find the most errors are not with pro se landlords. It's with one law firm. It's a law firm named Hanbury & Turner. They're not dumb, they're not bad people, but they read this statute as not being sequential. They just read it as saying, if I get all these things done, then I'm fine. And there are at least 2 district courts that have looked at this and said it is sequential if you do things out of order, like if you mail the summons and complaint before you ever tried to go out to the property, that's not good because you don't have the right to mail it until you've been unsuccessful at the property. Okay, so that's it for service stuff, and again, there's a whole section in the manual that gets nerdier about it if you want to get nerdier about it. Second thing I look at is whether there's any preconditions that the landlord had to do but didn't do that might give rise to a defense. I've got a number of ones here. I think the ones that I see problematic now and then, number 2, someone appearing for a company that's not, that doesn't have any kind of authorization to be there. There would need to be a power of authority to say that this person can stand in for this company. And if that person doesn't have something like that, the court doesn't have any knowledge that this person actually can be speaking for that entity. Another issue related to that is number 3 here, that corporate entities like limited partnerships and corporations have to be represented by an attorney. And if they show up with an agent, that's actually unauthorized practice of law. And so I'm always looking to see, and again, there's a difference between a kind of legally recognized artificial entity and one that's not legally recognized. So let's say I've got a company and it's like LM Properties. Okay? I don't have to incorporate. Now, I may want to incorporate in case I get sued so I can limit my liability, but I don't have to do that. And there are all kinds of companies that are out there that aren't corporations, and they can be entities and stuff. But the couple of things. One, the one that's not incorporated doesn't have to have an attorney, because the case law is only talking about corporations and limited partnerships and things like that. So if I'm not one of those, I don't have to have an attorney. But if I'm going to have someone who's a non-attorney, they have to have some sort of power of authority from the company to say that they actually have a relationship with that company. Now, the other thing related to businesses is down on number 6. If I'm incorporated, I'm registered with the Secretary of State. But if I'm unincorporated and I'm not registered with the Secretary of State, that's actually a defense, okay? Because I'm not supposed to engage the court system unless I register my company. Right? And so why do I care about that? Well, I care about that because there's a law that says that if a plaintiff that should have registered didn't register, a defendant of any kind, not just eviction defendant, but any kind of defendant can raise that as an issue. And what the court has to do is stop the case in its tracks until the plaintiff registers and award the defendant $250 in costs. Now, this probably doesn't get raised in multi-million-dollar litigation, but $250 is a lot of money to our clients. And so what do? If I see something that's not incorporated, it's not an LLP or an LLC, and it's not a full person's name, then they need to be registered with the Secretary of State. So again, if I'm Larry McDonough Properties, then I don't need to register. But if I'm LM Properties, I do need to register. So I talked to you a little bit earlier about looking up links, okay? And I mentioned that, if you go to links, I've got a link for the Secretary of State's website. And so I just click on there, I look up LM Properties, it's either registered or if it's not registered, I print it off, and the tenant can take that into court, show that to the judge saying, this place isn't licensed, or this place isn't registered, I'd like you to put this case on hold until they do, and award me $250. If my non-payment of rent claim is $1,000, I've just knocked that down by a quarter. So it's worth it to do that minimal investigation. Okay, so back to the answer. There are other preconditions here, but I don't see them coming up as often. I would just look over the whole answer form before you go to clinic. And the first time you go to clinic, you're going to be shadowing with someone anyway, and so this stuff will all start to sink in after a while. So don't feel bad if you're thinking, well, I'm getting a lot of information and it's not staying in my head right now. It will. It just takes a little repetition for that to happen. Okay, so I got about 15 minutes left. I'm going to move into non-payment of rent eviction cases, and these are the most common eviction cases. So I'm going to spend a little more time here than the other type of eviction cases. So I'll probably spend about 10 more minutes on eviction cases, and then I'm just going to spend 2 or 3 minutes on informal pauperous waivers, and then we'll take a break at 5 after. So non-payment of rent cases, by far the most common. And the most common defense by far is habitability. On some level, it shouldn't be a surprise. Most folks that have limited incomes are not paying to rent the fanciest places. And in my experience, landlords that are renting out renting out properties that low-income folks rent don't maintain them as well as other landlords. So quite often there are habitability issues. The law in Minnesota is that if the landlord has not maintained the property in reasonable repair and compliance with housing codes, the tenant has a claim for a reduction of the rent. And that reduction of the rent is based on the significance of the habitability violations and how they impact the tenant. So some things are going to be obviously significant, like no heat in the winter, ceilings caving in, no plumbing, no hot water, things like that. Some things that are more aesthetic may not be that consequential. If you maybe have some wallpaper that's starting to look a little ratty, it may be a habitability violation, but it may not be consequential, because it's only really consequential in an eviction case for non-payment of rent if it's going to lead to some reduction in the rent. Otherwise, we're just talking about something that's kind of academic. And so so when I look at raising habitability issues, is this something that's affecting you, and how is it affecting you? Because that's part of the case, is that this is the problem and this is how it impacts me. And if it's a big problem that impacts me greatly, then there's going to be a more significant rent abatement than not. A tangent related to that is what we just talked about a few minutes earlier, licensing, number 4. Landlords are not required by state law to license, But if a municipality says you have to have a rental license, then you have to have it. And the case law, it's not, I wouldn't say it's black and white case law, because the main case on this front is an unpublished Court of Appeals decision. But it analyzed in Alexandria a tenant who was in a property that was licensed part of the time but wasn't licensed for part of the time. And the court decided that for the period that it was unlicensed, the tenant didn't owe any rent. It's essentially an illegal contract that the landlord shouldn't be benefiting for renting out property that the landlord was not authorized to rent. So whenever I have a non-payment of rent case, that's another thing I want to try to find out is if the property is licensed or not. Now, the tenant may have seen something on the property, that some posting of a license. If they don't remember doing that, if I've got a case in Minneapolis, I can look it up online, but I haven't seen where I can do that here. So I would probably get on the phone and see if I can reach someone in the licensing department in the city of Anoka. Now, just because Anoka does it doesn't mean every city does in Anoka County, and I'd probably be surprised if the other towns in Anoka County had them, but they might. Okay? Find out if there is a license or not. Again, if there isn't a license, the tenant has a claim that they don't owe any rent. You might be thinking, well, that sounds like a big windfall. It is, right? But whenever you have lack of license, it's a windfall for one or the other. I mean, either the landlord's getting the windfall of rent that the landlord wasn't entitled to collect because the landlord didn't have a license, or the tenant gets a windfall of getting the rent back for something they rented and they got some value out of it. But in my view, I think it makes sense to, if the illegality is committed by one person, that the windfall go to the other. Okay. Number 6, if you have a tenant in a duplex or a triplex, it's possible that they have a shared utility meter. And the reason we care about that is there's a statute that regulates landlord use of shared utility meters. So this would be, and a shared utility meter is one that covers more than one household. To have a shared utility meter and have it be legal, the tenant needs to know that it was shared. The tenant needs to have had the opportunity to see a year's worth of billing before the tenant rented to see what he or she's going to get into in this relationship. Because when you have a shared meter, you don't kind of control your utility destiny, right? I mean, you can be as frugal as all get out, but if the other person isn't, you have a lot of bills, right? And so the idea is so the tenant can see that going in. And lastly, and perhaps more importantly, that each utility that is shared has to be apportioned reasonably. And so the violation I see more often is a landlord will say, tenant A, you pay water, or maybe you pay electricity, tenant B, you pay gas for the whole unit, and it'll just kind of wash out. And the law is specific to utility. So that's actually illegally shared metered. What the landlord should have said is, okay, here's the gas, and because you have same size units, we're going to split it 50-50. And here's electricity, same size unit, we're going to split it 50-50. Has to have some sort of reasonable allocation. You're only really going to see this in duplexes and triplexes when you get into larger numbers of units. Either there's going to be separate meters for each unit, or the landlord's just going to pay the whole thing and factor it into the rent. Late fees are regulated by statute at 8% of, limited to 8% of what has not been paid. Okay? So this is probably different than late fees that you've maybe seen in any properties that you rented in the past, where they were just flat fees. That's $50 after the 5th or something like that. Now, there's nothing wrong with $50 after the 5th as long as it meets the statutory requirement. So if I have $1,000 rent, $50 after the 5th is fine, because that's 5%, okay? But if I pay half of that, if I paid $500, so all I owe now is $500, and the landlord's still charging 50% or $50, now it's 10%, right? So the analysis is always comparing the late fee to what has not been paid. Okay? Let's see. This comes up a little bit, number 8, when landlords accept part payments from tenants. The landlord has to have a written agreement that allows them to evict for the balance. And sometimes that's in the lease. Sometimes it can be in a receipt. But if it's an oral lease and there are no receipts, and the landlord accepted a part payment of $500 on $1,000 rent, they don't have the right to evict for the $500 balance that's due. Tenant still owes the balance, but the landlord has lost the remedy of eviction for that. Now, the landlord can kind of get back on track the next month by saying, okay, next month, tenant, you pay me the $500 from last month along with $1,000, or I'm not going to accept it, or I'm going to give you, to do that, I'm going to give you a written receipt that gives me the right to evict for the balance. So landlord maybe only gets burned on this once, but the idea behind this law was to at least have some clarity, if the landlord wants to be able to evict for the balance, to have something in writing that says that to the tenant so the tenant knows that's going to happen. Okay, so I want to briefly talk about holding over cases. We don't see these very often. Non-payment of rent, by far the most common. Holding over case is when the landlord's saying, I'm on a month-to-month tenancy, I gave you a month to move out, I know you're up to date on the rent, I know you haven't had any loud parties, but I just want to rent to somebody else, or I have no reason at all, but I just want you to move at the end of the month and you don't move. So that's a holding over case. You can also have them with an expiration of a term lease. Lease was up at the end of February, we didn't renew it, I didn't move, you file a case to say, I'm holding over, so that's the term. So what are the defenses that come up there? If it's a notice case, was the notice proper? In a month-to-month setting, it has to be a 1-month notice received before the rent is due for what would be the last month. So if it's mailed on the last day of the month and rent's due on the first of the month, and it then shows up in the mail on the first of the month, it's too late, 'cause it's got to be received before the day the rent's due. Retaliation is probably the more common defense you see in these cases, where the tenant's saying, I had the housing inspector come out on January 15th, and then on January 29th, the landlord gave me a written notice to be out the end of February. The law presumes that notice to be retaliatory because that notice came in a 90-day window. It came within 90 days of when I did something to enforce my rights. So that's the window that we look at for that presumption. And the reason why that presumption is important is it's a very difficult presumption to rebut. The standard for rebutting it is quite high. So I'm always interested when I'm talking to someone who's got a notice to move out case is, did you do anything to enforce your rights in 3 months before you got that notice? And then tell me about that, because it has to be good faith, and it has to be something that ultimately we can prove. Okay. Then I'm going to go to breach of lease now. So you might be thinking, why do we have separate category for breach of lease? Because there's non-payment of breach of lease. It is, but it's kind of a separate category. Breach of lease in the landlord-tenant world essentially means anything other than rent. Okay? And generally what you're looking at, I'd say the most common defense there is materiality, which is number 2. A lot of landlords think any violation of the lease is good enough because it's my place, it's my lease. And they might even say anything in there is a material violation. It's for the courts to figure out what's material and what isn't. And what the court decisions say is that materiality is really kind of a fundamental thing. It's not just the landlord saying it's material, it's the landlord has to prove that it's material. And where this is going to come up is when breaches are maybe more annoying as opposed to really having more gravity to them. So clearly, the mad bomber killer, that's a problem, okay? So, things of violence, things that are either hurting other people or getting other people to want to move out, people fearing for their safety, things like that. That's important stuff. Stuff that's maybe more annoying, like, you don't clean the place quite the way I'd like it to be white glove clean, but there aren't any inspectors saying it's a health hazard. I would say would probably be on the immaterial route. A couple other things to think of in the breach area, and there's kind of a long list here, but I don't have enough time to go with them. A couple of the things that pop up with a little bit of regularity is if you ever have an eviction case where the landlord's saying you breached an oral lease by having a loud party, okay? Well, there are a couple things I'm thinking about. One, was there actually an agreement that the landlord can prove that was done orally about loud parties? That's one thing. But also number 5 here, to have a breach case, you have to have what's called a right of reentry clause. And so there would have had to have been an oral conversation that, 1, you can't have loud parties, and 2, if you have loud parties, I can evict you for it. So those 2 components would have to be there. Another thing that I see with breach cases is waiver, And the most common one I guess I see would be number 8. If the landlord, could have evicted me a couple of months ago but didn't, kind of sat on it because maybe I had the loud party back then, maybe it did violate a lease, but they've collected a couple of months' rent, there's case law that says they may have waived the right to evict me for that. Okay. If you have a tenant with a disability, number 10, and that's causally connected to something the tenant might have done that breached the lease, the landlord has an obligation to cut that person a little bit of slack. We call that reasonable accommodation. Okay. Now, I've got a number of sections related to relief here, but what I want to go down to is noting that, where do I have this? Attorney's fees.
And if you want 5 more minutes, Larry, go ahead.
Okay. Attorney's fees. If you have a written lease, take a look if there's an attorney's fee clause benefiting the landlord. Because if there is, a statute that I helped write about 10 years ago makes that reciprocal, so it benefits the tenant as well. So what that means is if you would decide to represent this tenant and you won the case, even though you're not charging the client anything, you could bill your billable rate to the other side. And I'm not saying do this to be some big moneymaker for yourself, although if it does, fine. But I find that as a settlement angle. I mean, if I can say to the other side, I'm representing on this, I'm an old guy, I work at a big law firm, I can bill out $500 an hour, so you wanna pay for me chatting with you and litigating against you, or do you wanna get this resolved? So I'm not in it to collect the fee, but I'm able to use that as basically a bargaining chip to say, there's a greater cost to you litigating this case, landlord, if you lose, if I'm representing. Okay, so last thing I want to do is just point you to the informa papyrus materials that you have in your packet. And so those are a little bit ahead of what we've just covered. If you go back to page 25 in your packet, and I would pull that up on the screen, but the version of Adobe Acrobat here doesn't allow me to
pull that up on the screen. So this is what it looks like in your packet here. It says Affidavit of Informa Papyrus. The first time you look at one of these, it might look like it's in a foreign language, and to some extent it is. If you've done these in the past, then you may have a comfort level with it. If you have, and you only need to do this if you're going to file a document. But if you think you need to file a document and you want to get the fee waived, you're going to have to do this. And this might be a good time, if you're shadowing with someone, or if you think you have to do it, maybe reach out to another attorney that's down there and help you go through the form. There are 2 forms here. One is court required and one isn't, but I use them both. The one that's court required is this affidavit. And the reason I use a table that's sitting right behind it in your binder is that this form tends to tease out income more than it teases out expenses. And 15 years ago, that wasn't really an issue. But I've had some experiences with some referees in Hennepin County where they're thinking, if I don't know for sure that the tenant's expenses match their income, maybe they got some money sitting around somewhere. And this form only teases out major expenses like rent, and all the day-to-day life expenses that we all pay aren't asked in this form. So if you think there's any possibility that a judicial officer is going to look at this form and see that this person's got $2,000 in income, but the only expense that's listed is $1,000 in rent, and thinking, well, there's another $1,000 there, so this person can probably afford to pay the fee. If you think if you know that's not going to be a problem, then maybe you don't use the table. But if you're not sure, it doesn't take that much longer to use the table. And the table is kind of self-explanatory. I just made this table based on what I thought the most reasonable list of expenses are. And then I attach that table, and it does a couple of things. One, if it doesn't tell me, if I'm still left with a big gap and this person doesn't have any money in the bank account, then I think I'm missing something, because if they did have this extra money, they'd have it somewhere, right? But more often what I do is I find out what I thought I was going to find out. This person's income is $2,000 a month, and their expenses are actually $2,200 a month. And so occasionally they're going to mom or dad or a brother or sister for an extra couple $100 to try to make ends meet. Or maybe they don't make ends meet, and that's why they got credit card debt. So again, you only need to do this when you're going to file a document. And I would find these days I'm not filing documents that much on eviction cases. Now, Mariah's going to talk a little bit after the break about motions for expungement. And when you're doing a motion for expungement for a case that's already done, you are going to have to file a document, and so then you're going to have to do the IFP. One more thing related to expungement is there is a settlement agreement form in here, and if you're helping someone settle a case, that's the form that the county uses here in the court system. And the box that I want you to not ignore is the one that talks about expungement, because there's a box there for if the settlement works its way through and everything turns out fine, that the court can automatically expunge the case, and then this case stops following the tenant around. Okay? So we're going to take a 5-minute break and start up about 1/4 after. Thanks. I didn't think I'd closed out your slideshow, but I'm not, oh, there it is. Okay. All right, is that okay?
It was fantastic, yeah, thanks.
Okay.
Appreciate it.
Sorry, I went a little over.
No, that's fine. I think a 10-minute break is a little long for this group, so that's okay.
Okay.
We have plenty of time.
Cool. Nice binder you put together. This is comprehensive.
Thank you.
And let me know how it's going filling shifts, because maybe I could come up and do some. So just kind of keep me posted on where your gaps are.
Yeah, no, it's nice that we have Becky here, a staff member who's dedicated to this, so, because we're really expecting to have her just be here
Okay.
to train people and cover shifts.
Okay. Good.
So we've got pretty good coverage. We're just kind of struggling on Ramsey. I don't know if we want to cover shifts in Ramsey, but we'll see. And then
Yeah, I'm going to try to do a little more recruiting for that. I thought I'd kind of wait and see what we could do here, but I thought I'd do another round of recruiting, because we do have some folks that live over in that part of town that might be game for doing that on the way into work.
yeah. Like I said, and I think Anoka would be nice to get you folks here too, just because I think there's a real opportunity to go in on cases
Mhm,
and
yeah.
take good cases.
Yeah.
So,
Yeah.
so we'll kind of see how it all unfolds.
Yeah, well, the people that I targeted, a couple of them, if they end up being part of this, I mean, they're tough litigators. You know, they'd probably want to do more than just send somebody in.
Mm-hmm. You know, the other thing that we can do too is, just because I'm not expecting Becky nor our volunteers to go in on cases, but watch for good cases and then run those by your folks
Yeah.
too. And kind of knowing we have somebody in our back pocket that might be interested in doing those.
Yeah.
You know, the good cases tend to be easier to place, but
Yeah. Yeah.
that's another thing. It just helps to know that we've got a few more people
Yeah.
that
Yeah.
possibly be
Okay.
interested. But I know CMLS and Judicare are interested too in
Yeah.
advocating on those cases.
Okay.
So,
Good. I'll keep you
great.
posted.
Yeah, thank you very much. And are you gonna hang around or?
Yeah, I'm gonna hang on.
Okay, all right, and please, raise your hand, jump in, whatever.
Okay.
Get on. there's something I need to do. Does it work here?
I was gonna see if, I could plug it, unplug it and plug it back in, it might be awesome. Because that might just kind of reset it enough, but I don't know where she plugged it in. That would have been the other option. I'll just message. Cause the USB is out and plugged in somewhere, I just don't know where.
There's USB. Do you know what? I just found the on button.
Oh. Let's see here if that does it. Oh, perfect. But does it make that noise every time?
No, I was going backwards.
Oh, okay.
It's all good now, yeah.
Cause I was like, we don't want it to be that.
The on button is always a good place to start.
I didn't realize there was one, so.
Neither did I.
All right, well, welcome back to the second half of our training. I think I failed to introduce myself the first time around. My name is Mariah Kruger. I'm the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network. Also, just want to introduce Becky real quick, if you don't mind standing up. Becky is going to be starting with Volunteer Lawyers Network next week. She's going to be in charge of the Anoka County program, so those who will be working on site will be working with Becky. So for my portion of the training, I'm going to talk about two major topics. The first one is I'm just going to talk about the clinic processes a little bit, go through a little bit about the administrative needs on Volunteer Lawyers Network, and just some nuts and bolts about providing clinic services. And then the second thing that I'm going to talk about is eviction expungement. The only two legal topics that we're touching on today are eviction defense and eviction expungement. Now, the clinic at Anoka County is open for general walk-ins on any housing issues, so it is possible that there will be other housing issues that come in during the clinic times. There's no way we're going to cover all the topics in a 2-hour training, but there are a lot of resources. The ones that Larry went through, VLN has other CLEs on site. Every year, Volunteer Lawyers Network has an annual housing law seminar where we talk a lot about different topics. That's coming up here on Thursday, March 26th. Registration information is in your binders if you're interested in that. So there's a lot of ongoing opportunities to learn about the different housing issues. I think it's really these are the two that you're going to see the most at the clinic. So that's why we've decided to start with those and then branch off from there. But starting into the clinic process, just to let you know a little bit about the clinic, like I said, it's been actually going on for quite some time, but we're expanding those services. We're super excited to have this partnership. And the partnership on site actually includes 3 different service providers. We will be there along with Central Minnesota Legal Services and Judicare of Anoka County. So there always will be 2 attorneys from different sites as long as we're fully staffed. Also, there's going to be financial assistance. So Anoka Care of Emergency Assistance of Anoka County will be there on site. So like Larry was saying, most eviction cases are for non-payment. So figuring out the payment options is a big part of what tenants will need to do at the initial appearance calendar. Having emergency assistance on site is a fantastic resource. People can sit down and talk with the county. They won't be able to know that day whether or not they'll be able to receive emergency assistance, but they can start the application process if they haven't. Sometimes tenants have already started the application process and just need to know what's going on with that process, or they can find out that they don't qualify for emergency assistance and get connected with other resources. Sometimes there are other resources out there that need a denial from emergency assistance before those resources will step in. So it really is an important referral for us to make to our clients, and we're very grateful to have emergency assistance there. Emergency assistance also, interestingly, one of the things that they've been doing is also screening people for other other needs, and told us just the last time they've been signing up people for medical assistance. So even though they weren't able to get the emergency assistance that they need, they were able to access other county resources through emergency assistance being at the initial appearance calendar. The second referral that you can make, and our third partner is Mediation and Restorative Services, MARS, out here in Anoka County. So these are the mediators. Not all of our cases are going to be right to send to mediation, but there is a certain type of case that does very much benefit from mediation. Mediation is working hard to get to pre-eviction cases, so people even before they get to the initial appearance calendars or the eviction has been filed. But they also are available at the eviction calendar. Some things to know about mediation: both parties need to agree to the mediation. So if a landlord doesn't want to do the mediation, a landlord does not have to do a mediation. Most landlords will agree to do a mediation, and if that's ever a hang-up, I would always raise that issue to the mediation folks and ask for their assistance on that. Another issue is if it's just the landlord's attorney that has showed up on site. Some landlords will mediate sometimes, but some landlords' attorneys will mediate, but a lot of times they will not, so it's not an option at that point. The other thing that we want to make sure too before people go through mediation is they have a good understanding of any legal defenses that they might have. So we really do want people to have visited with the legal clinic before they go into mediation so that we can do the screening for defenses and give people a good sense of what their legal options are before they go into mediation. Also, just a quick note, the eviction calendars in Anoka County are every Monday and Wednesday. They start at 8:30. It is a general appearance calendar, so there will be other cases that are heard on the calendar at the same time. But Anoka County has reduced their calendars, has reduced the housing cases to just 2 calendars a week in the hopes that we can get enough people through, that people can take advantage of the clinics. So a little bit about the clinic process. So the housing court clinics are on the 4th floor of the courthouse, which is connected to this building just down the hall. So you're going to go through security, go around the corner to the elevators up to the 4th floor and down a long hall. We'll have an office conference room that will have a computer inside that's connected up to both the internet and printing, and we can get courthouse documents from it. The Anoka County Law Library has been very gracious in providing clinic assistance support. So it's John Murphy or someone else from the Anoka County Law Library who's going to be there with a table just out in this long hallway with the intake sheets for our organizations. What we want him to do is sort of he's going to be doing the client flow, making sure that clients who get signed up get heard in the order that they've been signed up for, and also making sure that they get referred to all of the services that they need to be. What I do want you to know is when you get the clients, you're going to get the clinic data sheet. And the tenant is going to have been asked to fill out the front side of the clinic data sheet. And the clinic data sheet has the demographic information on it. So in your materials is an example of a clinic data sheet that's we've filled out. So we want people to see what a good clinic data sheet looks like. A couple issues on it. At the bottom is a description of what the services are, that we're just a brief legal services clinic and there's no ongoing representation. So those are our disclaimer at the bottom. And then also at the very bottom, we have, we ask people for a citizenship attestation. One of the reasons is certain funding that Volunteer Lawyers Network gets, we need to know the citizenship status of the case. If a person is not a citizen, we absolutely don't want them to sign, and someone doesn't have to sign. But if people are willing to sign, it does help us because we can count those cases for certain numbers. So when you get the clinic data sheet, if you want to take a look to make sure that all of the information is filled out, including the income, and the 2 signatures at the bottom, we really appreciate that. One other thing that we are going to ask you to look at this clinic is to take a look at the income guidelines. So our clinic is reserved for people 300% of the federal income guidelines or lower. Now 300% is a pretty generous amount. I actually have a chart of all of the income guidelines here. And for a single person at 300% of the income guidelines, it's $3,100 a month. So most people will qualify for our clinic services at 300% of the income guidelines. We do reserve our full representation services for those that are 125% or less of the income guidelines. So when you get the clinic data sheet, I do want you to take a quick look to make sure that they qualify income-wise for our clinic. And then if they don't, that'd be something that we would want to reserve our services first for those people that do qualify. We don't see that too often, but every once in a while we'll come through with someone with a 6-figure income, and we just have to politely explain that our services are reserved for people who can't otherwise afford legal services. Your role at the end of the clinic visit is going to be to fill out the back of the sheet. So the tenant at the beginning won't be filling out the front, but they'll be filling out the back. And you'll be filling out the back, excuse me. I'll talk about that more just a little bit. One other intake issue wanted to point out to you is that VLN serves both landlords and tenants. Judicare also does landlords and tenants. Central Minnesota Legal Services will only do tenants. However, the type of landlord that we serve is a very narrow category of landlords. It's going to be a landlord who lives in an owner-occupied unit, and they're going to meet our income guidelines with their rental income included. We do actually in Anoka County see a pretty good number of landlords, and the type of landlord we see are family members who are evicting other family members or overstaying guests. Sometimes we see domestic relationships that have gone bad, parents evicting children, that type of thing. In this setting, a parent needs a child to leave, or and sometimes it's brothers and sisters, that type of relationship. It still is a landlord-tenant relationship, so we will see those help those landlords in that situation. It's something we need to keep an eye out for too when it comes to conflicts. If you have already served a landlord in a case and the tenant comes in the door, it is possible that that tenant could come in the door afterwards, or both want to be seen. It's not a problem as long as we have 2 legal service providers at the clinics, because the landlord could be seen by VLN and the tenant could be seen by CMLS. But it is just something to keep an eye out for, because we do see a few more of those cases here in Ramsey County than we see at some of our other clinics. So here's the clinic data sheet. And one of the things the people in my office will love you for is if we fill out the clinic data sheets completely. And there are a couple things I just want to point out about that, and I've highlighted. Make sure to fill out your name at the top and make sure it's legible. It's one of those things that we spend a lot of time searching if we can't read your name. And then a brief description of the legal problem. Here, 2 sentences, non-payment of rent, and if there's any obvious defenses, if it's a landlord that you're representing, if there are habitability issues, just a little bit about what's going on in the case. And then in the action and advice section, here we want to know what type of advice you gave somebody. Did you talk about settlement procedures with them? Did you talk about habitability claims? And we have filled out a clinic data sheet on there just so you can see an example of how much you want to write in here. We do recommend that even though the clinic can be busy, not fill out the clinic data sheets until the end of the shift. We recommend that after every client, you take a minute and fill out the back of that clinic data sheet with information before moving on to the next client. This is important information. All of you, if you're signed up to register, or if you're registered as a Volunteer Lawyers Network volunteer, you are covered by our malpractice insurance, and we do go back into our database and we input all of the information on these clinic database into our clinic database from the clinic data sheets. So we're going to know who you met with, what type of advice was given, and about how long that you met with that person. The other thing that you can do too is you can get CLE credit for volunteering. You can get up to 6 credits, I believe, and it's 6 hours of volunteering per credit. So if you want to come back to us before your CLE reporting period is done, we can quickly run and find out how much time that you've spent volunteering with us. So we want to know about your action advice. If you remember to put the case number in, that's helpful too. It helps us to follow cases. We do try to follow cases after clinic services here in Anoka County. We try to follow things like if a trial was set, how the trial went, if there were expungement provisions in the settlement agreement, was the eviction ultimately expunged, and having that case number helps us do those things. We also want to know a little bit about the area of law. Most of them, you're just going to check off eviction action here. That means you talked about an eviction defense. But all of these are other areas that you could possibly talk to somebody about. And then we just want to know the level of service that you provided. Was it just legal advice? Did you just talk to somebody? Talking to somebody would include, writing down a checklist, printing out a document for somebody. But was it legal advice only? Or did you go ahead and did you draft some documents? Was it an eviction expungement case and you actually drafted some eviction expungement motions and an IFP affidavit? Or did you go out in the hallway and did you talk to the landlord a little bit and try to negotiate a settlement on behalf of the client? Or did you take it one step further and did you go into a court and get the case dismissed for a client? All of those are levels of services that we want to make sure that you check off so we know exactly what happened. And then how much time you spent with the client. And it doesn't need to be exacting. We're not 6 minutes, anything like that. Just let us know approximately. If you don't write anything down, we assume it's 20 minutes. That's our kind of minimum for clinic services. But make your best guess, 30 minutes, 40 minutes, an hour. Let us know how much you spent with them. And at the bottom, that's just for our internal, but also good for you to know just some common referrals that we send people to. So if you're thinking that you need a referral for ongoing representation someplace else, those are the information at the bottom of the sheet. Any questions on the clinic data sheet?
I have one.
Yeah.
So you mentioned something in the person is not U.S. citizen, not to make the person sign this.
Mm-hmm.
Or which form?
There are 2 signature blocks here, and the second one is easy to miss. So all clients, before we serve them, we want them to sign this one. The second one, clients don't have to sign that. And if you have any concerns that they're not a citizen, I wouldn't worry about it at all. It's just that we can report citizen numbers to one of our funders, and we want to report as many of those cases as we can, so it's helpful to us. But if people don't want to sign it, I always just say VLN doesn't care. We just have some funders that do. But it does help us, and I get yelled at a little bit less if we get those signed as much as we can. Not that I would ever get yelled at for anything. Okay, for the advice session, just some general suggestions for how to handle an advice session in a clinic situation. I think the first thing when you want to do is lay the foundation. And I always just start off saying, this is a brief legal advice clinic. I'm going to try to talk to you about your case. I'm going to look for defenses. I'm going to see if you have any legal defenses to this case. We're going to talk a little bit about the process, and I'm going to allow you to ask questions. However, we've got about 20 minutes to do this. So I need you to be reasonably concise with what you're going to say to me, and we're not going to be able to talk for a very long time. Also want you to know that when you step out the door, I won't be representing you any further. So I'm happy to talk with you about the process and send you in the right steps, but just so you know, unless we specifically agree, I'm not representing you afterwards. And I think those are really good words to start off your advice session, so people, it is in the signature place where they're going to sign on the clinic data sheet, but just to be clear with somebody, it's legal advice only, and it's brief, because we want to keep it to about 20 minutes so that we can get to everybody. I think that helps set the stage for what we're going to do next. I also want to talk a little bit about confidentiality. Just reassure people that everything that they tell you is confidential. You do have the attorney-client relationship, even though it's just legal advice. And asking people to be as forthright with you as possible really helps you provide them the best advice possible. And then I just go through and explain what we're going to do. And I sort of like, the first thing I want to do is I just want to take a look at a few things to see if you have any obvious defenses. So there's a few defenses that I like to screen for on everybody. And we'll talk just a little bit more about those. And then, the description of the process and answering questions. And once I sort of finish with my spiel, then I want to sit down and I want to look at the underlying paperwork if I haven't already. So like I said, you're going to be in a conference room, and that conference room has a computer with internet access, so you'll have access to all of the resources that Larry talked about. And we also have, it's MPA remote, or it's the courthouse document system, where we can, it's like Mincis, except that the actual documents are linked there. So when I pull up the document for the eviction action, I can actually click on the complaint and I can see the complaint. And I can click on those service documents and I can see those service documents. So the first thing that you're going to want to do is you're going to want to take a look at that underlying paperwork. You're going to want to pull up the complaint and see what the eviction is for. And your tenant may bring that complaint with them and they may tell you, hey, it's non-payment, but I'd still pull it up and see what it says in there. When I'm screening for defenses, one of the things I always do is I always look at the monetary amounts that they are claiming in there. Most cases are for non-payment of rent. I always look and see how many months are they claiming that are due and ask the tenant, do you dispute that you owe this rent, and talk about that. Another thing that I'm going to look at is late fees. I'm always going to look to make sure that the late fees are limited to 8% that what are due. The other thing that I'm going to look at is in an eviction action, the landlord can recover the costs of the case. So that's going to be the filing costs, service costs. And I'm going to look at those filing costs and service costs and make sure that they're reasonable. The filing fee is $305, and service costs, $100, $125. I think if they get up to $150, that's when I start to get a little questioning of them. But really, landlords, when they're asking for court costs, it's usually about $425 or so that they're able to recover. So those are the things that I'm going to look at initially when I see the complaint. Next thing I'm going to do is I'm going to look at all those service documents. And as Larry was saying, service is a jurisdictional defense. So if the service isn't done correctly, it's something that we want to make sure that our tenants are raising. So do pull up all the service documents, make sure you're looking at those to find out if service was appropriate. The other thing I'm going to do is I'm going to take a look at the named plaintiff of the case, that landlord. I'm going to do the research to make sure that if they're a business, that they're properly represented, that you can also look at the Anoka County property records and make sure that they're the owner of the property as listed, some of those things there. And that's really my quick list of defenses that I'm going to make sure that I screen for other times. I'm also going to listen to the tenants and see what they have to say. A lot of times, like even the rental license, it's hard to, it's not something that I think we can screen for every time in the clinic because we'd be calling around to all different cities. But if a tenant comes in and says, hey, I know that my landlord's not licensed, and that would be one thing that would also put that on my list then to say, all right, let's take a minute and see if we can figure out what city to call and find out if your landlord is really licensed. Any questions on that? Couple other resources I want to make sure that you know that you have. Like I said, we have a computer with printer and internet access. MPA Courthouse, so that's going to be able to, so we're going to be able to look at all of the underlying documents. VLN is going to have a file box with printed materials that are the most common ones that we think you're going to need. But we started this clinic mid-February, so there may be more documents that we find out that you're going to need. So if you ever have any feedback for Becky or I going through, please tell us. But this is similar to what we've used for another clinic, so this is what we're going to start off with in that box. Also, just a reminder that legal aid and adjudicare attorney is going to be on site. And then you can always call me as soon as Becky has a VLN number. I'm sure she'd be happy if she calls. And Larry is always available too. So if you go through all of this and you're not able to have what you need, make sure to reach out for resources. We don't ever want you to feel like you need to guess at something. There really are enough resources, hopefully, to support you in what you're doing there. Okay, also just a quick slide. And just to give you a heads up, people are going to come through and you're going to be like, oh my gosh, I don't know that there's much that I can do for you. It really looks as though you owe this rent. Emergency assistance is going to able to help you, and I don't see any obvious defenses. So just want you to know that when it feels like there's nothing you can do, you can sit down and you can talk about the hearing process. And just real quick, what happens is before everybody comes to the clinic, they need to check in with the court clerk. Then they're going to get sent back out in the hallway, and they're going to be asked to negotiate with the landlord some type of settlement. Once they reach a settlement, that settlement then is going to go back into the court and be read into the court. So just sort of explaining to people what that process is helpful. You can explain to tenants their minimum rights. So let's say that you can't come up with a payment plan and your landlord won't negotiate at all. Tenants can ask for up to 7 days to move if moving is what they want to do. There's also the right of redemption. Tenants have the right to redeem the property, and that's to pay everything that is due, all of the rent that the landlord claims is due, in addition to the court costs. That's one of the reasons why the court costs are so important to go over. And even if the landlord can object to that. So at that point, the tenant has the right to redeem if that's something that they want to do. You can also talk about how and when the writ will be issued and executed. And Larry did a beautiful job of going through the process of, if you can't reach a settlement today and you ask for 7 days to move, even if the writ shows up on your door, right after that 7th day, there still is some time in that process. So just letting people know, and people do come in and they think, I'm going to need to get out of my property this afternoon. And it's not an uncommon belief, but just explaining to people how the process goes, I think is one of the services that we really can provide to people. Another thing you can do is you can refer the client to other on-site resources. I would say mediation is a fantastic resource, particularly in some of these familial eviction cases. When we have the landlord, mom, dads that are evicting the kids, a mediation can be a great resource for those situations. Also, if you send someone to emergency assistance, then they can also help them access other resources that might be helpful. And then the one other thing is I always like to do a little bit of screening for other issues that a tenant might be having problems with. So sometimes repairs get raised at the eviction setting. And there might not be a lot we can do about those repairs. But you can talk about that tenant, how going forward, if they do have repairs that need to be made, that they can write the 14-day letter and do a proactive rent escrow action as opposed to raising it in the eviction setting. Want to just put a quick caveat about raising repair issues at the eviction setting. If a tenant is going to raise repair issues as the reason for non-payment, the court then is likely going to ask them to pay the rent that is believed to be due into escrow in order to proceed with the case going forward. And I think this is really important because one of the fastest ways a tenant can lose a case is to say, hey, I want to litigate, go to trial over repair issues. And the court will say, okay, the landlord says you owe January and February rent for $1,000 a month. You need to pay $2,000 into court by next Tuesday. And if that tenant doesn't come up with that $2,000, to pay into escrow, the writ is issued at that time. So it's just something to be aware of in the repair issues, that that tenant needs to be prepared to pay any amount that's alleged to be due before they'll be able to proceed to a trial on repairs. A couple other things too, just things like tenants who are paying in cash. Anytime a tenant pays in cash, the landlord needs to provide a receipt, but tenants should not be paying in cash, and just encouraging people to never pay in cash. If people pay in money orders, a receipt of a money order shifts the burden to the landlord to prove that the payment was not received. So just some proactive knowledge about how payments are made. There is the Attorney General's office puts out a really fantastic landlord-tenant handbook that can be handed out, and John usually has them at the table. We have a copy of one in our materials, but it's another good resource to give out to both landlords and tenants that gives a good description of their rights in the landlord-tenant setting. Also want to talk about settlement agreements. So in your materials, we have the Anoka County Settlement Agreement form. This is the form that we would like our volunteers to use. Just to let you know that every attorney, landlord attorney's office has their own form. So you will see some different versions of these. But I think the Anoka County form is quite good. I really like their eviction expungement provision in here. They talk about automatic expungement, and I can tell you not every county has an automatic expungement provision in it. But a couple things about helping tenants with settlement agreements, and you will be doing a lot of negotiation of settlement, or a lot of advising on settlement agreements. The settlement agreements need to be very exact as to time, date, amount, and location of the payment. If a payment is written on the settlement agreement and it's missed, the moment that set payment is missed, the landlord can come into court and ask for a writ. So making sure it's clear, and it's on page 91, excuse me, the settlement agreement is on page 91. So when you're talking to tenants about payment plans, make sure that it's a payment plan that the tenant has a reasonable chance of accomplishing. And it happens more often than you'd think, that tenants get backed into a wall, into settlement agreement plans that really don't work for them. So you're going to be talking about things like, when is the next time you're going to get paid? How do you get paid from your job? Is it automatically deposited into your account, or are you going to have to go to get a check, take a check to a bank? And then thinking time-wise to make sure that the tenant can make that payment at the time, date, and location as stated in the settlement agreement. And it really is an opportunity to just tell the tenant to slow down and make sure that you're giving yourself enough time to make the payment. And that giving yourself enough time is also in the context of, you're going to be negotiating with a landlord that wants that payment probably as soon as possible. So, but it really is important to be specific. The other thing is, if a tenant is going to be receiving a payment from the Salvation Army or from another nonprofit or government source, instead of the form of payment, you can write a letter of guarantee. And what that means is that the landlord doesn't have to have the actual check from emergency assistance. They just have to have a letter from emergency assistance which says that they are going to pay the amount. So once again, it's a little different, because it's not that the landlord actually has the check in their hand, but if the settlement agreement says letter of guarantee, a letter of guarantee from the nonprofit will be sufficient. Some other things to think about, make sure move-out date is clear, and sometimes there are settlement agreements for move-out dates, especially if it gives someone more than 7 days. Repairs to be done by a landlord. If the tenant is complaining about repairs, you can write repairs that the landlord needs to make into the settlement agreement, and I think it's an excellent way to address repairs if you don't want to take them further down the road to trial. But the tenant certainly has the right to put some of those things into the settlement agreement. You also want to talk quite a bit about expungement when you're talking about settlement. going to talk just a little bit later about the impact of an eviction on someone's record, and the impact of an eviction in this market where there's very few affordable units available to people. To have an eviction record on your rental history makes it almost impossible to find an affordable unit. So in this, and also evictions are on a tenant's record the moment it is filed. So before that tenant even sits down in the office with you, they have an eviction on their record if they are there to respond to an eviction complaint. It doesn't matter if they settle the case with you that day. It doesn't matter if they paid their landlord even before they've come to court. That eviction is going to be on their record until an affirmative request is made to get it removed. These settlement agreements are excellent opportunities to make those affirmative requests to get them removed. There's a couple different ways that can happen. One way is there can just be a caption change, a caption and an index change. But this is just where the court continues to keep the docket, so the record is there in the court, but the name of the tenant is removed to John Doe. So those sometimes landlords will agree to just that, particularly in cases where the court is going to be maintaining jurisdiction over the case, particularly if there's a settlement agreement that's going on. You can use the caption exchange to take the tenant's name off the case immediately, but still have a settlement agreement that goes on afterwards. And I think you just put a provision in there. This one, settlement agreement has for an automatic expungement, and basically what's that saying? If you can get the landlord to check that box, that the court will automatically expunge it unless the landlord does an affidavit of non-compliance, which I have to say is fantastic. Both in Hennepin and Ramsey County, we have the opposite situation where they check the box and it's an affidavit of compliance, and a court will only remove it if an affidavit of compliance is filed. Here's the reverse, is the court is automatically going to take it unless the landlord files an affidavit of non-compliance. So you may find that there are landlords out there that won't be willing to check that automatic expungement, making them file an affidavit of non-compliance, but they might be willing to do something with an affidavit of compliance. And that would mean once all of the terms of the settlement agreement are met, that either the tenant or the landlord can file this affidavit of compliance, which says, everything in the settlement agreement was met. As we've said it met, please court expunge this record. Just a note about that, this is where the IFPs come into place. If the tenant is going to file an affidavit of compliance on their behalf, they'll either have to file an IFP to get the fees waived or pay the fees. Now, because VLN takes clients that are up to 300% of the federal poverty guidelines, courts go up to 125% for the IFPs or lower. So sometimes we need to advise our clients that they'll need to be prepared to pay the court cost if they're the person to file the affidavit of compliance. So just something to be aware of. Sometimes landlords who have already paid the filing fee and wouldn't need to pay an additional filing fee to file the affidavit of compliance will do that, and it's not a cost to the tenant. But the tenant, if the tenant wants to keep control and ask to file that affidavit of compliance themselves, they just need to be aware of that potential cost issue. Does that make sense? Okay. And then the one other thing that can be put into a settlement agreement is to talk about positive or neutral rental references. And if you have a landlord that's willing to put something like that into a settlement agreement, if they're not willing to expunge, that's an excellent thing to have in a settlement agreement. Any questions about settlement agreements in general? Okay. So that was just what I was going to talk about on the clinic process. Before I jump into eviction expungements, does anybody have any questions about the clinic process in general? What we are going to do is we'll do training through shadowing. So we're staffed so that VLN will have a staff member with our new volunteers until they are prepared to take the shifts by themselves. We expect it to take a period of time with people, and we expect it to vary amongst people. Some people might want someone to shadow them longer than others, and really we just want people to get to the comfort level, because there are, in the clinic setting, it's fast-paced, and you need to be prepared to make those judgment calls and provide people advice right there on the spot without necessarily being able to go back and do lots of research at your desk. So, okay, real quick about eviction expungement. And just real quick, I talked about the impact of an eviction, and most people know that, but just you need to know that it is on your record the moment it's filed. It doesn't matter if you even went to all the way to trial and won the trial on the eviction. It's still going to be on your record until you've made some sort of effort or request to have it removed. Tenant screening agencies can report cases for 10 years, but court records can be available indefinitely. So anybody could just sit down on MinSys and do a name search and find out if there's been an eviction on that person's record. There are extremely low vacancy rates in rental housing right now, so that black mark makes it hard for people to find housing. And there is a disparate impact. Evictions look a little bit different in Hennepin, Ramsey, and Anoka County, but I can tell you that when you go, if you've never been to the initial appearance calendar in Hennepin County, it's quite startling, actually, and it's just a very interesting experience to watch, and it's the disparate impact of evictions is recognizable from the outset. There was a 2016 study, and it's quite old now, but it showed that 50% of residents in two Minneapolis zip codes, 55411 and 55412, experienced an eviction within the past 3 years, and those are both North Minneapolis zip codes. So it really is true. I should ask too, has anyone read Matthew Desmond's Evicted? It's a fantastic book, and it talks really about, if you're interested in evictions at all, I highly recommend it. I'm going to go on to other things, but it talks about the market of evictions too, and how someone can pay just as much to rent something that is of a much poorer quality, but they're not necessarily paying less because the property isn't as well kept, and it has more to do with market forces and how those market forces keep certain people in certain places. The other thing I just want you to understand is that evictions can be a cycle too. So say someone had one eviction, and if you're living in a rent burdened household, so more than 30% of your income is going to your rent, and some sort of unexpected expense comes up, like a funeral, and it's really not uncommon that funeral expenses, it's surprisingly difficult for people to pay for funerals, and they are expensive, or car expenses, or a sick kid, or something like that. They can't go to work, can't pay rent, they end up with that first eviction on their record. That first eviction is that black mark, which makes it difficult to rent from a good landlord. So then they're renting from a slumlord substandard housing, which ends up in the second eviction, which those two evictions then also makes it difficult to find good housing, and the third eviction comes along. So we really do see a cycle with evictions. One way we can help people get out of that cycle is through eviction expungement. And just when we talk about, you can do expungement without a separate motion, but what we're going to be talking about next is filing that separate expungement motion. There are three legal standards for eviction expungement by motion. You can do it through mandatory authority, statutory authority, or common law and inherent authority. Talk about a mandatory authority. The first, and this is the one situation in which if you plead these facts, a court must grant the eviction expungement. These are cases for contract for deed cancellation or foreclosure. And it just really got to go through, read the statute, and if those situations exist, you can do a mandatory authority expungement. Statutory authority is given to the courts through the statute, and there's essentially a three-part test. And that three-part test is the case sufficiently without basis in fact and law? Is the expungement within the interests of justice? And are the interests of justice outweighed by the public's interest in knowing about the record? So in my opinion, this really boils down to sort of two tests. The first one is there an error in the underlying case such that it shouldn't have been brought, or the landlord shouldn't have won the case at the outset? And then second, does justice today demand that we take it off the records? And just to give you sort of a look forward to, the third test is inherent authority. And in the inherent authority test, essentially the court is looking at just the justice arguments. It's saying, okay, there isn't anything in the underlying case that was faulty, or there wasn't an error there, but we'll still look at just the justice argument in the inherent authority test. So whenever I'm looking at eviction expungement, what I'm going to do is I'm going to pull up the underlying case. I'm going to take a look at that complaint, look for all of those defenses that I would have looked for before. I'm going to pull up the service documents, really look at those service documents carefully, and then talk with my tenant and determine if there is some sort of defense or error in the underlying case that it shouldn't have been brought anyways. If there is, I'm going to plead both statutory authority and inherent authority. If I can't find anything that went wrong with the case, and maybe the case was ultimately brought to trial, there was a full trial on behalf of both parties, and was ultimately found in favor of the landlord. Be a situation in which it might be hard to argue that there was an error in fact in law. I can still go ahead if the underlying justice arguments are there with that case. And we do see in Anoka County that cases where there was no error of fact in law at the beginning, or at least not one that we can raise in the motion at that point. We can go ahead with just those justice arguments and be successful with eviction expungement motions. And once again, for the statutory authority, what we're going to do here is we're going to look at all of the, without basis in fact or law, look for improper service, inappropriate plaintiffs, serious habitability issues, breach of lease, and then all of those other defenses to the eviction. For common law authority, I'm just giving you the legal sources here for common law authority. And I would just see there's a recent case, Minnesota Court of Appeals in 2019, just to be aware of it. There's an excellent concurring opinion in there. However, the case itself has some interesting law about inherent authority. Just want to point out. Also want to point out the Minnesota District Court document retention policy. So the court's document retention policy actually says that unlawful detainers may be destroyed after 1 year if there's no money judgment ordered. It's a may test. It certainly isn't a must test, and the court doesn't follow this, but it still is a good argument that we can bring forward if the case is over a year old and there's no monetary judgment ordered. And I would say one thing about this money judgment, a money judgment doesn't just mean that money is owed. A money judgment means that there was money owed and the landlord then took additional steps to docket that with the court so that it's that judgment is listed with the court someplace. If it's over 10, if there is a docketed money judgment and it's over 10 years, then the court may once again doesn't need to hold on to the documents after that time. And I think those are good guidelines for us when we're looking at cases. I do have to say, even under the inherent authority, it's important to look at whether or not money is owed. And it may be that 1 year is not long enough, depending on a few other factors. But in general, I think this is a good guideline to use. We have two cases, this at-home case that I pointed out earlier under the inherent authority test, and another slightly older test, but really this is where the court goes through what they think are important inherent authority factors. I've pulled through what I think are important factors to look for when looking at expungement. One, I think, is look at the underlying case. Was it dismissed or was there a judgment in the client's favor? I think anytime we see a case that was administratively closed, is how it's usually listed on the document, or dismissed, or the client won, that those are really easy cases, in my opinion, to file those eviction expungement motions and get them off people's records. Another one is looking at, was there a settlement agreement, and was that settlement agreement satisfied? So a lot of cases are what we call pay and stay. Someone went to court, set up a payment plan, met that payment plan, and continued to rent from the landlord till the end of the lease. Those also, I don't think there needs to be even a 1 year wait period on those. I think those, these dismissals and settlement agreements satisfied are one that if the tenant has some other strong factors with them, that you can go ahead and ask for those pretty readily. A note on the settlement agreement, however, sometimes we see settlement agreements where it's clear that money was still owed, but the settlement agreement didn't talk about the money. The settlement agreement was just to vacate on a certain date, or maybe it dealt with another issue. I think that would be one situation where satisfaction of the settlement agreement might not be enough, because it sometimes does happen that there's settlement agreements where both parties know that the money isn't going to be forthcoming for the tenant, so they sign a settlement agreement on something else. I think it is important to look at if the rent is still owed to the landlord, and in particular, is the landlord needs to be served with the eviction expungement motion before the hearing date. Is that landlord going to come and object and ask for their money back? I think those are harder cases when the money is still owed and the landlord is going to come into court and ask for that money, even if it's outside of that 1 year period. Was a writ ultimately issued, or did the client leave willingly? This is one of those ones that, what does the case look like overall for your tenant? Does it look like the tenant stayed until the very last moment? Was the writ ultimately, and you can look at the court documents to see if a writ was ultimately executed. And that means that the sheriff ultimately went out and forcibly removed the plaintiff from the tenant from the property. Excuse me. However, I would say that even if there was a writ that was issued and executed, I'd still want to ask a few more questions. I haven't had this same conversation in Anoka County, but I can say that I have been on the phone with a social worker in Hennepin County who told my client that in order to get her family into emergency housing, that she had to stay until a writ was issued in her case, that just getting the eviction filed in her name wasn't enough to get them into family housing. So I'd want to ask if a writ was issued and executed, find out a little bit more about what was going on. A lack of opposition by the landlord to the motion. So if someone comes in and wants to do an eviction expungement of a case and there's still a hefty amount of money owing, or if there's still money owing and it's maybe just a year or two old, what I might advise the tenant to do in that situation is to reach out to the landlord and say, I'm trying to get this expunged. Are you going to object? And if you are going to object over money, could we settle this case outside of court so that you wouldn't object? And then then filing a motion after that payment has been made, or that outside of court settlement has been made with the landlord to not oppose the motion, is a really good way to address those expungement cases, those evictions that can't yet be expunged because of money being due. Did the client continue to rent from the landlord after the eviction? That'd be sort of the pay and stay. They filed the settlement agreement and stayed. What has the tenant done in the time since the eviction and now? I think this is also a really important one. People pay their rent. There's an underlying reason why people don't pay their rent. It can be the family funeral, the broken down car. It can be the abusive relationship. It can be struggle with substance abuse. It can be health issues. It can be mental health issues. If those destabilizing factors were the reason why the tenant didn't pay the rent in the past, find out what's going on now. Has the tenant addressed their substance abuse issues? Are they working with a nonprofit who is helping them work through past problems and getting to stable housing today? Really talk about the difference between what was going on at the time of the eviction and today. And then once again, what are the tenant's circumstances today? Another one too, does the tenant have a job? What's the ability to pay? Are they working with a nonprofit that are willing to pay rent going forward? Have they qualified for Section 8 housing? Those sort of things I think is important to point out. And really the inherent justice argument is a big picture argument. So it's not just one of these necessarily. I mean, there are a couple important ones here that would be, but you're looking at the whole situation of what's going on in the tenant's life, and does justice demand that this eviction no longer be on that tenant's record because it's not an adequate reflection of whether or not they're a good tenant. These are all sort of the things that you're going to consider if you're doing an inherent authority argument. So the process, so when someone comes in and says, hey, I have an eviction on my record, I'd like to get it expunged. First thing you're going to do is you're going to run that name search in MinSys or MPA, and it's not uncommon that people aren't even aware of all of the evictions that are on their record. It's not uncommon that someone will come in and say, hey, I have an eviction from 2016. You'll pull up their name, and you're like, well, there's one from 2015 and one from 2018 too. And they'll be like, well, hey, we never went to court. I paid the landlord, and the landlord told me I didn't need to go to court. Well, it's probably true, but that doesn't mean that the eviction is still out there. They just didn't know about it. So you guys want to look up, do a name search, not just a specific case number search, to see what the evictions are that are out there. Then we have the motions, just hard copy motions in the office, and you're going to want to fill out one motion for each eviction. You can't put motions together. There has to be one motion filed for each eviction. And then for each eviction, you need to have an IFP. And this also is important to know. So if you had someone coming in and say they had 3 evictions, and if they don't qualify for an IFP, that's about $300 per motion. So it's important for tenants to be able to qualify under that IFP. If they don't, filling out that additional exhibit that Larry talked about is really important, because judges do have the ability to reduce the costs of filing. So it may be that a tenant doesn't qualify for a full waiver of fees under the IFP, but the judge will reduce the amount owed to $50 a motion or something that is feasible for the tenant. So even if you have a tenant who looks like they're over income, I definitely go ahead and fill that IFP out and use that exhibit and see if the fees can get waived. Also, something to keep in mind, multiple tenants. If you have, if you're going to have 2 unrelated tenants who are going to fill out a motion, you can do just one motion for both people. You don't have to have separate motions for separate tenants, but sometimes the court will then require an IFP for both tenant. And then also in Anoka County, they want you to include a proposed order with all of the documents for filing. So once you have drafted all of those documents, you're going to give them to your tenant. Your tenant is, or the client is going to have the motion, the IFP, and order for each eviction. And then they're going to go to the hearing desk, and civil filing in the courthouse is on the first floor, right? So we're going to go back down to the first floor and down a long hallway. And they can actually, once you finish the papers with you that day, they can go down and get them filed. You might want to just give them a heads up about service. They need to serve the papers on the landlord at least 14 days prior to the hearing date. It can be sent by regular mail, and the tenant can do it themselves.
Mariah, does the court have a proposed order form that it uses?
Yes. Okay. We have a proposed order form that we have in the office. I will check to make sure that it is and that we have them in the office, but yeah.
And do you know if the proposed order is more of a scheduling order form or it's a potential proposed order that would say granting the motion?
It's granting the motion, but it's quite generic. And then the signed affidavits of service, your tenant or the client does need to come back and file affidavits of service at least 3 days prior to the hearing. So just so when you're advising that your tenant or the client who's doing the eviction expungements, they kind of have a sense of what the process is going to be. Any questions on that? All right, that's my last slide. You can see we don't have Becky's phone number in here yet, but that's to be forthcoming. And that's my office number. Super grateful to have all of you here today. If there are any other questions, I'm sure Larry's happy to hang around for a few minutes. I'll be here happy to take those questions. Super excited. I know we've got a couple people who are already signed up for shifts. This is an ongoing learning process, so don't worry if you, this is more than you can take in all in one day. Certainly over time, there does start to be some patterns with things, and when you start to see those patterns, things will click. So thank you again, everyone, for